5 seconds to go. Start. Arguments raised on behalf of Arvind Kejriwal which tend to dent the statements and material relied upon by the DOE in the reasons to believe, though worthy of consideration, are in the nature of propositions or deductions. They are a matter of discussion as they intend to support or establish a point of view on the basis of inferences drawn from the material. It is contended that the statements relied upon by the DOE have been extracted under coercion, a fact that is contested and has to be examined and decided. This argument does not persuade us given the limited power of judicial review to set aside and quash the reasons to believe. Accepting this argument would be equivalent to undertaking a merits review. Arvind Kejriwal can raise these arguments at the time when his application for bail is taken up for hearing. In bail hearings, the court's jurisdiction is wider, though the fetters in terms of Section 45 of the PML Act have to be met. Special court would have to independently apply its mind without being influenced by the opinion recorded in the reasons to believe. To adjudicate on a bail application, pleas and arguments of Arvind Kejriwal and the DOE, including the material that can be relied on and the inferences possible, shall be examined. The court will have to undertake the balancing exercise. It has been strenuously urged on behalf of Arvind Kejriwal that the arrest would falter on the ground that the reasons to believe do not mention and record reasons for necessity to arrest. The term necessity to arrest is not mentioned in Section 19(1) of the PML Act. However, this expression has been given judicial recognition in Arnesh Kumar versus State of Bihar, which lays down that necessity to arrest must be considered by an officer before arresting a person. This court observed that the officer must ask himself the questions: why arrest? Is it really necessary to arrest? What purpose would it serve? And what object would it achieve? This court in Muhammad Jubair versus State of NCT of Delhi has held that power to arrest is not unbridled. The officer must be satisfied that the arrest is necessary. Where the power is exercised without application of mind and by disregarding the law, it amounts to abuse of the law. In Joginder Kumar versus State of Uttar Pradesh, the distinction between the power to arrest and the necessity and need to arrest is explained in the following terms. No arrest can be made because it is lawful for the police officer to do so. The existence of the power to arrest is one thing. The justification for the exercise of it is quite another. The police officer must be able to justify the arrest apart from his power to do so. Arrest and detention in police lockup of a person can cause incalculable harm to the reputation and self-esteem of a person. No arrest can be made in a routine manner on a mere allegation of commission of an offence made against a person. Stop.